what I found was very interesting about tax, that's the first. I mean, there have always been some exceptions about the process and stuff like that, but we're actually going to the second one and saying this doesn't count. It's the first time I've ever seen it change.
And close down, not close.
I was into your system.
Yeah, so here's what we should do.
But I had actually that page where it said
Yeah, we got that's the page. Yeah, you just have to speak about it.
There you go.
Well, actually, that's I'm here to just get my brain all going before I take it. Because they're not testing on this material. What they're learning today is like, well, it's stuff that I'll need. They got some everything, but to take the exam, so we're in transition right now. It's like they change law so much that they aren't testing that.
Yeah, that's what you have to do.
The whole law for the exam, I can all the new stuff.
Wilson on one side and Bracy's on the other, and say, guys, here's the deal.
I'm going to try and set that up. Because it's just horrific.
Now you're good to get ready.
So I was just plenty about that.
I'll switch you over. Here's your.
So my question is actually
Round one. All right.
if you see
Yeah, Bill is a great question.
Oh yeah, he's he's always right.
Yeah.
Good question.
Yeah.
Your firm is the one that got private.
Oh yeah.
They picked on you. You guys. Yeah, but I just want to. Okay, so okay, good. Because I saw you guys put in a wonderful response. Has that been resolved one way or the other?
No.
Still pending?
They're setting this up.
Yeah, because that's, I'd like to talk about that. Bob Stoll had mentioned, because I think he's like disclosure. They want to tee up some test cases. So is it okay if I bring up your experience?
Absolutely.
Yeah. Because,
No, Bob told me I want to take this case with knowing the law.
that's what I want, the point I want to make, because that's the point.
Absolutely. And I'm good friends with Bob. So,
You don't mind helping your fellow colleagues.
Yeah. I'll get his, yeah.
I think his derivation issue.
Yeah.
His derivation. That's
Yeah, goals, yeah, gotcha. Yep, there we go.
Okay, great. Thank you. Yep, slide advance if you want to use that water. Any questions? You're good? All right.
All right. You'll start talking and you'll sit down.
Yes, I'll go ahead and start speaking. I'll go ahead and introduce myself. I'm Bill Smith, of counsel with Woodcock Washburn. I'm virtually associated with our Seattle office, and even though I live in sunny Scottsdale, Arizona, it's always fun coming up here to Seattle, especially during the summer months. They don't have any issue with me coming up here. A couple of thoughts about Keith's presentation. As he said, AIA is the law. We have to live with it. There is talk that there could be a technical amendment to the legislation. How that will operate, whether it will happen, and whether or not it will be effective to clear up some of the ambiguities, we just don't know. So we have to live with what we have. And I seriously doubt at the next debate among the Republican candidates that they're going to say that the first thing they'll do if elected president, is repeal the AIA. I just don't think it's on their to-do list right now, so we do have to live with it. The other point that Keith made about the ambiguous terms and words in the statute. Bob Stoll, the present commissioner of patents, at least for another couple of weeks, has made it clear in a number of presentations that the Patent Office understands the ambiguities, and they're going to be setting up what they call so-called test cases as quickly as they can identify them and get them up to the board and determine on the outcome up to the Federal Circuit, trying to get some guidance. As Keith said, the 52 Act, we waited 14 years for Graham v. John Deere. The Patent Office is going to try to get some test cases, as I mentioned. And I was a APJ on the board for 19 years, and I have to say the idea of so-called test cases is kind of scary because the board, like the Federal Circuit, is going to be dependent upon the quality of the briefing that's presented to it. And one good sign is Rob's firm was selected in a test case on the issue of the propriety of restricting a single claim, a Marcouche claim. It's been an issue that's been dogging the Patent Office for a long time, and there's a board decision that came out that raised all sorts of issues, questions on this issue. Rob's firm filed a very thorough analysis, and hopefully the Patent Office will be able to select the test cases and select test cases on the basis that the firm representing that applicant and the applicant have the resources to provide a meaningful response, so that we do have good briefing up to the board and onto the court. Okay, the effective dates for those of you who have not been following the AIA. There were a number of provisions that are currently effective that went into effect the day it was enacted. November 15th, you have the electronic filing incentive. If you file an application by paper, it's going to cost you, I believe, $400. So they really want you to file electronically. And for most people, that's not going to be an issue, because I believe the Patent Office statistics are it's close to 90% of applications are electronically filed. The Patent Office has said that if, and I know this comes as a surprise to you, if the IFW is down and you're trying to file an application and you're not able to, and you say, well, I'm going to file it by paper just to make sure it's there on time, you still owe the $400. Their IT problems are not going to save you from that. Then the next milestone is going to be a year from the date of enactment, when a number of provisions come in to being that you're going to be hearing about today. And then the big date is March 16th, 2013. The first inventor, the file comes in on applications filed on or after that date. As Keith said, that's the law. If you wake up on March 15th of 2013 and say, oh yeah, I guess the law changes tomorrow, you're about a year and a half late. So you need to be aware of all of these procedures and the changes and adapting our practice. This came from the PTO's website, updated this week. As Keith said, there's going to be a number of rulemaking efforts that the PTO is coming out with as they implement these new procedures. The next big day, as far as we're concerned, is going to be in the middle of January, where the NPRM would be the new proposed rulemaking, where they will be published in the Federal Register, and that will be the day that we find out the Patent Office's first thoughts on how all of this is going to be implemented. There's going to be a very hard and fast 60-day period for response. No extensions of time because the train has left the station. Patent Office has very tight time schedules, so it's going to behoove us to the day they come out to read them with understanding and get involved with the comments. The 12-month effective date where there will be rules coming out include the Inventor's Oath and Declaration, the third-party submission of prior art. I'll talk about those two briefly. Other speakers will talk about the supplemental examination and the other topics. The 18-month effective date, that's the so-called G3 rulemaking, first inventor to file derivation proceedings, and then repeal of statutory invention registrations. Maybe Chico or Mike know about statutory invention registrations. Why was this such, ended up in the legislation? I'm not sure anyone's used it, but I guess it's going to be the end of them. Okay, the PTO wants your input. They have been very, very vocal about this since the statute was signed into law on 16th. We had a window of opportunity to comment before the PTO formulated their rule packages. That window has basically closed now because the rule packages for the G2 rulemaking are before OMB for approval and will be published in the middle of January. But as the PTO wants your comments. Okay, and these we're taking from the PTO's website just this week, and you can see the comments by organization. A number of individuals, the comments they've received so far, 47% are from individuals. So we all have a stake in the new patent law, and we all have individual and unique circumstances. So we do need to make our views known to the Patent Office. Comments by subject area. You can see where the concern or the interest has been so far. Contested cases has been big because of the advent of the IPR and the PGR. By subject matter, you can see also how the breakdown is. The PTO has on their website, if you go down to the bottom, they have a link to a microsite, an AIA microsite. And there, as you click through, you'll be able to read the comments that have been received. You can obviously see who they're from and see what the thoughts are. And the comments are will be obviously taken into account. USPTO procedures, you'll be hearing a lot about the different procedures from the speakers that follow me. I just picked two that I saw were not going to be covered. Pre-issuance submission by third parties. Right now, there is a provision that if you are monitoring a competitor's application on FAIR, that you do have a window of opportunity to submit prior art to the Patent Office. It's not, as far as I know, it's not been used frequently, but I do know it has been used for various reasons. If you use it currently and also the way it's being amended, you can submit the prior art without identifying the real party in interest. You can retain a different law firm that has no association with you or your client to make the submission. One of the issues with the prior program was that all you could do is just submit the prior art reference or references, the document. You could not comment on them. And that is always a scary proposition when you're handing the Patent Office what you believe to be a good piece of prior art, and then you're depending upon the patent examiner to advocate your case for you. Okay? Now, with the provisions, with the new provisions, the submission must set forth a concise concise description of the asserted relevance of each submitted document. So now you can provide a commentary as to why the document is relevant to the patentability of the claims of the application. Whether this will become used more frequently, I'll be interested to see. The present program I heard someone describe as a poor man's re-examination before the patent is granted. If the patent office, if you submit a good piece of prior art in your mind and the patent office does not properly use it in your mind and the patent is still granted, will you be able to rehabilitate the reference, perhaps in an ex parte re-examination? Under the current law, if you can present it in a new light, you can go back, you can have a re-examination on so-called old art. So it would be interesting to see if this becomes a more used procedure. Interesting, it applies to any patent application filed before, on, or after September 16th, so it's available right now. Okay, oath of declaration and filing. Keith mentioned this briefly. It does create a few more options if you have an inventor who has disappeared or an uncooperative inventor. It's interesting the way the legislation is written. It talks about that a notice of allowance cannot be issued by the patent office if the oath or declaration has not been filed. So instead of filing it without the oath of declaration, waiting for your notice of missing parts, under the new process, you will be able to work trying to get the appropriate signatures, and if not, to make the appropriate representations concerning the missing or uncooperative inventor. I think the best practical advice is a signature in hand is going to be worth 5 promises that I'll sign it tomorrow, so that you should have your paperwork, the assignment, oath, and declaration prepared as soon as possible and signed and submitted as soon as you can. Okay, prioritized examination. You'll recall that the Patent Office in previous years had come out with a three-track proposal for public comment. A number of the tracks were not widely popular, but what they call Track 1, where we could pay a fee and go to the head of the line, the Patent Office did like, and they were prepared to implement it, except that they were running into a funding problem. That when they were prepared to implement it, there is no guarantee that any money sent in would be able to be spent actually on the program. So now the Track 1 has been implemented. The Patent Office is very, very excited about this. Bob Stoll and his talks and Peggy Focarino, his replacement, have been pushing this, and Keith alluded to it. If you go into Track 1, pay the $4,800 fee, you are told that the final disposition will be on average within 12 months of the request grant. Importantly, for some people, the application must contain or amended to contain no more than 4 independent claims and 30 total claims. And to date, the Patent Office has said that 853 applications were filed in last fiscal year, which ended September 30th. And so far, this fiscal year, beginning on October 1st, 703 applications were filed. Now, the Patent Office can cap this at 10,000 applications. I didn't do the math as to whether 703 works out to more than 10,000 for this fiscal year, but it is a popular program. And Bob Stoll had mentioned the IPO PTO day. So far, 9 applications have already been allowed under this program. So they did not break them down as to whether they were filed in September or from October on. But this brings up the issue of what the conundrum that Keith presented, that if you are the third or fourth person in line to file and you pay your $4,800 and you go to the front of the line and your patent is granted first, what happens to the people who were first, second, or third to file? As Keith said, the Patent Office doesn't have an answer for it. I think thinking in theory, if you're the first to file and you ultimately get your patent issued, one would think a re-examination, you could take out the patent, or the competitor's patent may not be valid on its face. But it is a conundrum and can present business problems where you have your application pending while your competitor does have their patent issued. Now, one of the thoughts that Bob Stoll again has mentioned as a practice tip, the requirements to go to the first of the line are just that. You pay your $4,800, you have your 4 independent claims, no more than 30 claims, you go to the head of the line and you get your first office action. After that happens, you can amend the case to include more claims. You can take extensions of time. And what happens is the prioritized examination is terminated, but the amended case goes on the patent examiner's amended docket when you respond to that office action. So that means that according to the examiner's performance appraisal plan, they will have to pick that up for action within 1 to 2 months. So with that thought in mind, the $4,800 is just the price of admission to go to the head of the line. And then after you get that first office action, then if circumstances demand that you no longer qualify for the prioritized examination, that's fine. You've got what you paid for. Your application has been picked up out of order. Also, keep in mind that this program is available for continuations and divisionals. So in terms of a strategy, if you're trying to get applications issued early, you could file a continuation that meets the guidelines, possibly get a narrower claim allowed quickly, and meanwhile you can fight in the patent office for your broader claims when your case comes up for action. Section 25, priority examination for important technologies. I just reproduced that section of the statute because that's basically what it says. Provide for prioritization of examination of applications for products, processes, or technologies that are important to the national economy or national competitiveness. I think it'd be an interesting question would be, what technology is not important to the national economy or national competitiveness? Does anyone have a client that is making commercial products that wouldn't think that they fit in to one of those categories? I assume this will be subject to rulemaking, and it's going to be interesting to see how this fleshes out. And as Keith alluded to in his presentation, AIA is a creature of politics. A lot of compromise, a lot of lobbying went into it, a lot of give and take. The old saying is you don't want to see how sausage and legislation is made, I think applies to the AIA. So this is something to keep your eye on, because if you have clients in a particular area, like right now, Green Tech has a special program that Bob Stoll had said they're going to be trying to phase out, I think in lieu of the $4,800 program. So if you have clients well, you have to really be advising your clients when this rulemaking comes out whether or not they want to try to get their particular industry included. Appropriations and fees. Fee diversion is not ended, unfortunately. Over the years, the Patent Office became a user fee funded agency. I believe what was it in the Reagan administration when Congress, when they were split on how to come up with a budget. This is back when Congress would actually pass a budget every year. A number of senators and representatives were sequestered on at Andrews Air Force Base, and they were tasked with, you're not coming off the base until you come up with a budget. And when they came out, lo and behold, Patent Office was a user fee funded agency. For those of us working in the Patent Office, that was a surprise, but it sounded like a good idea. It sounded like we had a dedicated stream of funding. Well, what happened over the years is that the Patent Office collects the fees, but they have to pay them into the General Treasury Fund. And then every year, the appropriators in Congress appropriate back a budget amount to the Patent Office. And as politics came about, there came a time where there was one party that was not in power, wanted funding for particular projects that the other side was not willing to fund, and the other side said, well, if you can find funding for your projects, we'll go ahead and, they'd be fine. So this is when somebody said, oh, the Patent Office, they don't need all of that money. So sure enough, then they would just appropriate back only a percentage of what the Patent Office had collected. Over the years, it's hundreds of millions of dollars. You wonder why the IT systems in the Patent and Trademark Office, at least on the patent side, are rather decrepit and less than robust. It's because of the diversion, hundreds of millions of dollars. So they have not been able to upgrade their infrastructure, IT infrastructure. They haven't been able to hire the number of examiners that they've wanted to hire over the years, and it's been a terrible way to try to run any type of business. So part of the AIA debate was, could this be the end of user fee diversion by Congress? And I believe there was a Coburn amendment that was being voted on during the floor debate in the Senate, and I happened to have CNN on, and when it came up for a vote, I can't remember who the senator was, but he came onto the floor waving this piece of paper saying that they had the signed letter from, I believe it would have been Hal Rogers, the chief appropriator in the House, saying, don't worry about this, folks. You don't have to worry about this Coburn amendment that would guarantee, in essence, the Patent Office gets all of its user fees back. We're going to handle this. Trust us. Okay. Well, so the Patent Office is still a user fee funded agency, but they still do not have guaranteed access to all of the funds they collect. It still is an issue. And again, this is something that Keith alluded to. Patent attorneys are not, we're not politicians, but we need to keep the pressure on the politicians to stop diverting the Patent Office's funding. As you can see in the statute, it says the authorization to spend all fees deposited in this fund should be, not will be, it should be provided for in the USPTO's annual appropriations. When this spending authorization provision is provided, the PTO will have access to spend all patent and trademark fees it collects. When really means if. We're not out of the woods yet. I think for this fiscal year, the Patent Office dodged a bullet. In large part, the Congress passed what they called the minibus bill in November, I think right before Thanksgiving. And Bob Stoll and Dave Kappas have said that for this fiscal year, they're in good stead. They plan on hiring 1,500 examiners this fiscal year. I know Mike may mention that the board is actively recruiting up to 100, Mike? Yeah, 100 new APJs for the soon-to-be PTAB. So we're not out of the woods, and again, we need to become more involved in the politics behind the Patent Office. Our clients are paying the money in. They expect the Patent Office to have the fees to make it a functioning entity. Fees, authority for the director to set just fees to recover, again, the aggregate estimated costs of the office relating to patents and trademarks. That means that each proceeding within the office does not have to have a fee associated with its direct cost recovery. There will be some programs that are subsidizing others. I think Keith had mentioned, and others have talked about, that there is some concern about the fee-setting authority, whether or not it could be used, in my words, say, in a punitive way or in a way to direct behavior one way but not another. The fees that are going to be charged for the IPR, the inter-parties review, and the post-grant review in a large way could affect how popular those programs are. So the Patent Office is going to have a lot of discretion on this, and it's going to be interesting to see how they use that. Again, at the bottom, the $400 surcharge for applications not e-filed. Again, if the IT system is down when you're trying to file and you decide to make sure it is filed today, you will have to charge you will have to pay the $400. One of the provisions was this 15% surcharge that went into effect 10 days after the legislation was enacted, which the 10-day date was September 26th. And the office had been trying, I think this proposal had been in Congress for probably over a year, trying to make up for the fee diversion. And just the way the politics are in Washington, D.C. these days, nothing happened, and finally it came through on the AIA. But what happened is unintended consequences, and this is something Bob Stoll was just scratching his head about. Not unexpectedly, the bill was signed on September 16th, and we were told on September 26th, all of our fees are going up 15%. A lot of people prepaid fees. Notice of allowance fees, I think, maintenance fees, a lot of cases were filed earlier than perhaps they would. In all, Bob estimates that they lost about $200 million because that money was paid in last fiscal year. It was an unexpected windfall. You would think, oh, it's a windfall for the Patent Office. No. Right now, Congress is keeping that money according to the Patent Office. So we can hope from this time period on that Congress will keep their hands off of our money, but again, we need to be aware, certainly all sorts of national IP groups, AIPLA, IPO, ABA, we are all made aware individually of the budget issues as they come up, but what we need is to have each of our voices heard in Washington. That concludes my presentation. Are there any questions? Yes, Steve.
I had a nomination statement. Does everyone understand what he meant by the $200 million? Congress puts a cap on what the PTO can spend. It goes to the general fund. All this money got rushed in early. They're capped. They got the money. It's lost. So I make a very bold request that the patent bar needs to support the patent office configuration. IEEE USA for about 10 or 15 years has been indicating that it really thinks the patent system and the patent office. We've sent a lot of letters to Congress. essentially a lockbox for the patent office. They don't want to call it a lockbox because it's a derogatory form of thanks to Social Security. But it's a lockbox, and the money goes in the lockbox, and it piles up and beats. And you know what's going on in Capitol Hill with Committee 12. Now you have an adversarial relationship between the director and Congress. This money piles up in that lockbox. The poor director, Director Campos, is now in an adversarial relationship with Congress as they try to fix other fiscal concerns. It raised the hurdle for the director and it's made the job harder. We need to help the patent office. Somehow this needs to be done.
Right, and you may remember as former Speaker Tip O'Neill famously said, all politics is local. And after living outside of D.C. for 30 years while I was in at the patent office, it's easy to become jaded about the political process, and people say, well, it's all bought and paid for by lobbyists. But you'd be surprised that either as individuals, law firms, corporations, writing letters, personal letters to your representatives and congressmen, they do have some oomph to them. I think a lot of what they receive, if it's just a form letter you print it off and signed your name to, those are probably not as effective. But we need to get, I think, more passionate to make sure that the patent office does get the funding that we're paying for. To me, it's just a crime that they've been siphoning off these funds.
And one other comment in regard to what you just said. Judge Rogan, we all know this, former Commissioner Rogan, told me a few years ago that importance of contacting your representatives. He said, you need to approach them and tell them what your concern is and what you're going to do for them if they help you and what you're going to do if they don't help you. And I thought it was one of the best pieces of advice that anyone could give me. And also because we're in Washington State, for those of you who did not see what happened in the Senate, Senator Maria Cantwell really stuck up for the issue of this bill. To the extent we had interaction with her, the patent bar in the state needs to thank her. She made play a role down the road with corrective legislation. She made play a role with respect to finally someday ending the diversion. And those senators, those congressmen need to hear from the patent bar to realize that they have support from the industry in their state. They know when they stick their neck out on an IP issue, they are getting support. Because we're going to look to those people to fix these concerns in the future.
Speaker?
I do interferences for a living. I want to talk about the impact of that prioritized examination on interferences. Not so long ago, there used to be a rule that provided that when you requested an interference, you'd get prioritized examination, and automatically, beautiful. From my perspective, if you're trying to provoke an interference, there is a public interest in getting the thing off and running as quickly as possible. Somebody's going to win, somebody's going to lose, but the public needs to know who's going to win, who's going to lose. We don't have that rule anymore. And it can take 5, 6, 7 years to get an interference. Well, that was a horrible case, but 4 years is common to get an interference up and running. But now, for $450, you can go to the head of the line. File the application, copying the claims, suggestion of interference, and pay, or is it $480? Whatever it is, it's cheap at twice the price. Okay.
Thank you, Bill. So Bill is Bill's an attorney here at Woodcock Washburn, but he lives over in Phoenix, and he was kind enough to bring the nice weather with him today as well. One thing we didn't mention is that Bill was an administrative patent judge at the patent office for 30 years before he started practicing with Woodcock here. And he jumped in at the last minute this past weekend. We needed a second speaker to add to the session. We called up Bill, and he jumped right on. We thank you for coming, Bill.
Just a birthday airplane.
And Bill's going back to the airport right now. Thanks. Next, we're going to have Charles Golds. Charles is also known by his name Chico to many of his friends. He's at Oblong Spivak. He's been practicing for 40 years, And is that right?
Yeah?
Did you not want me to tell people that? Chico practices primarily, almost exclusively, in basically the area of interferences, and today he's going to talk about derivation law and derivation proceedings at the Patent Office. Thanks, Chico.
Yeah, I'm looking forward. By the way, is this working? If you can hear me in the back, would you raise your hand? Okay, got the lavalier in. All right. It's been interferences for 40 years, but I am very much looking forward to these new proceedings, including the derivation and the others. Life is going to get very complicated, and that's good for attorneys. I mean, that's how we make our living. The more complicated they make the procedures, the more billing there's going to be. This actually is part of it which I think is not going to make a tremendous difference, because I believe that the derivation proceedings are going to be very much like the derivation interferences that we've been handling that I've been handling for 40 years. They're not going to be identical, but they're going to be pretty darn close. So it's not going to be a huge change, I think. Mike can tell me whether it's going to be a huge change, but that's what I'm going to tell you is I think they're going to be pretty close. First thing is derivation is not necessarily theft. People talk about derivations being theft of the invention. In the 40 years I've been doing this, I've had exactly one case that involved breaking and entering in the nighttime and taking pictures of documents and that kind of stuff. That's not what derivation means overwhelmingly frequently. What it really means is the two real parties in interest used to be friends. They're not friends anymore, but they used to be friends in some kind of a relationship. Vendor-vendee, joint venture, distributor-distributee, anything the two companies work together such that they talk to each other and communicate information back and forth. That's the most common. But there is another huge subset, or a minority, but a big minority. It's people running off their mouths. IEEE meetings, and also salesmen, engineering salesmen. They're paid to go out and get drunk with customers. They get drunk too, and they talk. And you can say that's terrible, but it happens, and it's always happened, and it's always going to happen. That kind of communication between people just happens, and you have to live with it. Which brings us to the last line. Sloppy work by lawyers. We're going to talk about cases that involve a lot of money, and usually, I was going to say almost always, that's probably an overstatement, but at least usually, if the lawyers had done their jobs to begin with and had really looked into the inventorship question and had worked things out amicably, you could have saved a ton of money. Derivation usually means that one or more than one individual has gotten the idea or part of the idea from an individual or more than one individual from another. It's cross-fertilization. That's good. I mean, that's how technology moves forward, this kind of cross-fertilization. We want to encourage that sort of thing. But it has to be done in a context where the people that are putting in the money, the people that are paying for the improvements in technology, have control over who owns what. If this cross-fertilization involves people who work for the same company, that they're joint inventors. That's a problem in itself. But when they work for different companies, then they're still joint inventors, but you have to work it out and know what the law of joint inventorship is, and in particular, who owns what when the joint inventors come from different companies. If any of you do work with foreigners, Japanese, European, anybody other than American, I believe that this is a true statement that the American law in all of this is unique. At least it is totally different than what Germans, French, and Japanese deal with on a day-to-day basis. And therefore, these kind of foreign clients tend to assume that since we're all civilized people, our laws are the same. Well, they're not. And foreign clients assume that when there are joint inventors, they automatically have obligations to each other. Well, that's not true in the United States. Unless the parties agree otherwise. This is always subject to agreement by contract. But all too often, there ain't no contract. So then you get the default provision. And the default provision is that if there are joint inventors from different entities, then each one of those individual entities can commercialize the invention independently without accounting to the other companies at all. So if you have joint inventors from two different companies, there's a famous case that where one company had spent a ton of money litigating the patent, and then and finally was won and was looking forward to a huge recovery, and then the other company said, how'd you like to buy a license? And sold the license to the deriver for the, not to the deriver, sold the license to the company that was infringing for a lot of money, but less than it was looking to pay if it had simply had been mulcted in damages in the infringement litigation. So I'm not talking about this area of the law except to tell you our law is different and foreign clients get confused on it, and it's up to you to let them know what's really going on. To be a joint inventor, whether they're people in the same company or two different companies, you have to have contributed, I love this language, less ambiguous language, something significant to the invention, as defined by at least one claim in the patent. So if you put in dependent claim 97 and you recite something that was contributed by the guy from the other company, suddenly that other company has the right to license that whole damn patent. Again, that's not what I'm here to talk about, but at the back of your mind, you should know that joint inventorship is decided on a claim-by-claim basis, and it's enough to get a person on it if he contributed something that is something significant that is recited in any one claim. Okay. How derivation litigation can be avoided? Primary cause is sloppy lawyer. In many cases, it could have been avoided if the lawyers had really looked into the inventorship issue. Now, I know for those of you who work in companies, this can be toxic. This can be very, very difficult within the context of a company to go to somebody, and particularly somebody who's the head of the laboratory or otherwise well placed in the corporate hierarchy, and say, I've looked into what you contributed and you don't qualify as an inventor. People want to have their names on patents, particularly if they can smell that it's an important one. But if you don't look into it and you don't figure it out and get it right, then it can cost a lot of money. Another thing to be said is you only avoid the litigation not only if you figure out what the laws are and who are the joint inventors, but then you come up with a legal solution to the problem. One hears many lawyer jokes. Lawyers make jokes about business people, and the jokes we make about business people, at least the ones I hear, tend to be that it is second nature to business people to collude and conspire and violate the antitrust laws. I have a degree in economics. There is no question whatsoever that you can maximize profits for your company by violating the antitrust laws and not getting caught. So the reaction of businessmen is to come up with an agreement that would violate the antitrust laws. The lawyers cannot let them do it. You have to keep control on what they are going to agree on to deal with these issues of derivation. How derivation litigation is handled now. I'm going to tell you what the law is today, and as point has been made for several times already. This is the law that is going to control us a lot of the time for the next 15 years. The cutoff date, March 16th, that's prospective. There are going to be new interferences declared for at least the next 10 years. And so this law that I'm going to talk about is what the law is today. It's what the law is going to be for most cases for the next 1, 2, 3, 4 years, and then for a declining fraction of cases for the next 10 years. It's going to be a classic decay curve in this kind of law. Derivation can be a defense to a charge of patent infringement if you've got your inventorship wrong on the patent. Then the patent is invalid. You've got to have the inventorship right. It's a requirement of American law. A lot of people, including me, think it's a cockamamie requirement, but be that as it may, it is the law. And derivation is simply a species or a subset, subgenus, of the genus of improper inventorship. So if you have a derivation situation, you haven't dealt with it correctly, that's a defense. If the infringer can prove it, gets off scot-free. But that's not the interesting one that I'm here to talk about. If both of the involved parties filed patent applications, and at least one of the involved parties charges the other with derivation, the issue can be involved in and can be decided, determined in an interference proceeding. And that's what I'm here to talk about, because that's the sort of thing I've been doing for, as he pointed out, a long time. Interference proceedings may be also in district courts if both parties have patents. These are very, very rare, and they should be even rarer than they are. Why do I say that? There are very few district court judges who know much about patent law. Those who know anything about patent law know about infringement law. I think it's fair to say there are none of them that know much about interference law. So patent interferences in district courts have led to some just abominable opinions. You do not want to try an interference before a district court judge who has no familiarity with interference law. So what usually happens when both patents have issued, that means the patent office made a mistake. They shouldn't have both issued, but it happens. One or both parties file applications to reissue their patents, thereby restoring jurisdiction to the Patent and Trademark Office, and it becomes a patent applicant or an applicant interference before the board. Derivation interference. All right. BPI consists of a large number of administrative patent judges. How many you got now, and how many are you going to have in a year? It's over 100, isn't it?
About 100 judges, of which I have 60 contested cases, so we're a subset.
Yeah, the small subset, 16 handle contested cases, most of which are interferences currently. Not all of them. There are a couple of weird ones that they also handle. I still call them Atomic Energy Commission cases, although it has a different name now, and NASA cases. They're actually ownership disputes. They are contested cases in the Patent Office handled by the board under the same rules as they handle interferences. The APJs are techies. They have special training in patent law. Those who handle the contested cases have special training in interference law. No juries. No juries. That you sell to clients and they just glow when they hear no juries. And no judges, I believe this is a fair statement, who majored in medieval English literature or political science. When I say they're techies, they're chemists, they're electrical engineers, they're mechanical engineers. They're some of us. They're real people. Interferences are fast, relatively fast. Several of the points I'm going to make, relatively is the key word. Clients bitch and moan at me about how slow interferences are, and I tell them, well, Just compare this to an infringement litigation in Massachusetts. That would last 4 times as long. And that's absolutely a true statement. But the clients do not tend to be greatly mollified by the fact that the APJs are faster than Massachusetts. They want them to be faster than the Eastern District of Virginia, and that they aren't. But that's relatively fast. Most interferences are decided at the administrative level in less than 2 years. The internal standards of the patent office, of the board, encourage the judges to decide the cases within 2 years. I have heard from former APJs who work for my firm that their sustained superior performance awards, what most civilians would call bonuses, are a function of the average pendency time, so they are encouraged to decide them quickly. But the only metric that they have is within 2 years. So we get an appalling number of decisions at the 1 year, 11 month, and 3 weeks. I've got one that is 2 months short of the 2 years. We would love to have a decision. I think you know what case I'm talking about. Both parties. I have shared my unhappiness with opposing counsel. He's just as unhappy as I am. We both think we should win, but we both really would like a decision. Our clients would. Again, relatively, interferences are relatively cheap. Compared to what? Compared to ex parte prosecution. Compared to reexaminations, the current reexamination law. Most cost less than $2 million in outside counsel fees. What I tell clients is most cases settle. And if they settle quickly, then they can be a lot cheaper than this. But if they don't settle, then you're looking at $500,000 to $2 million. An occasional one goes over $2 million, but not many. So that's the kind of money you tell your clients you're looking at. Derivation interferences, the current law, can also decide any other patentability issue that can be decided in patent infringement litigation. So currently, derivation interferences, and this is a contrast, I'll make this point when I get to derivation proceedings. Most derivation interferences, I call them derivation interferences, they're the ones that have a derivation issue in them, but they also have all the other issues. You're not just limited to a derivation issue. So you're talking about patentability, scope of the proceeding, et cetera, et cetera. Decisions by the board are reviewable either by direct appeal to the Federal Circuit or by a civil action in a district court with subsequent appeal to the Federal Circuit. So again, derivation interferences are a distinct subset of all interferences, but they're interferences. So any general statement you can make about all interferences apply to derivation interferences. The most distinctive aspect, I think, of derivation interferences is they tend to be very hard fought because they involve face. A typical priority interference. Both sides want to win, they'll spend money, but it's just business. It's just business, no hard feelings. Derivation interferences are not just business. There are hard feelings. The parties hate each other, often, because what you're saying is that the other guy is claiming something that he's really not entitled to because he got it from me. And that creates a lot of emotional baggage. Most derivation interferences involve reciprocal charges of derivation. Parties were working together in some fashion. 3 of their guys, 4 of our guys got together in conference room A. When they went into the conference room, they didn't have a solution. When they came out, there was a solution. Whose idea was it? Typically, the 3 guys from one side and 4 guys from the other go back, talk to their patent counsel. Each company files a patent application naming only its guys, because that's what people do. It's not what they should do, but that's what they do. So you get that kind of reciprocal charge. Again, this leads to hard feelings. House counsel typically have their rear ends on the line because if they had really done their job and looked into the looked into the inventorship issue, they could have avoided all this problem. So these things can be very embarrassing for House counsel, and that also leads to a level of hard feelings. This is one where it appears to be different, although that depends on the rules that Mike is in the process of writing. Currently, either party can initiate a derivation proceeding. Whether you filed first or you filed second, it just doesn't make any difference. Either party can kick off the derivation interference, and it doesn't really make any difference which party kicks it off. The issue has to be decided. That's not true in derivation proceedings, at least it's not necessarily true. Derivation is frequently alleged and infrequently found. See my article on the subject where I collect some of the opinions on that. If you read the opinions, they'll say that derivation, like any other interference issue, is decided by a preponderance of the evidence. That's what the case law says and has said time out of mind, and you need to quote that in your briefs because that's the law. But it doesn't feel that way. It really doesn't feel that way because their honors don't like to find derivation. I think that's a fair statement because they know when they find derivation they're saying, you're a bad person. They don't like to say that. So to persuade them that there has been derivation, it feels like clear and convincing evidence. Case law doesn't say that, but boy, that's the way it feels. And in those rare cases where you don't have overlap of pendency, and therefore the rules provide for the burden of proof to be clear and convincing evidence, I've had one like that, it felt not like clear and convincing evidence. It felt like beyond a reasonable doubt. I was a prosecutor in my youth, and proving anything beyond a reasonable doubt is hard. It's supposed to be. There are societal reasons for that. And trying to prove derivation when there's not copendency is really, really tough. How derivation litigation will be handled under the new Act. Improper inventorship may no longer be a defense in infringement litigation. This is extremely controversial. There's an excellent Patent Leo article by Josh Sarnoff, who is a professor of patent law at DePaul University in Chicago. He argues that it will not be a defense anymore. And it's a good, solid piece of academic argument. The problem is that the result he gets strikes me and many people as ludicrous. That can't be the law. But if Congress says it's the law, then it is the law. So it may be that you won't be able to rely on derivation as a defense in litigation. Even though the patent names the wrong person, that may not be a defense. It is counterintuitive in the extreme. Now, the owner of a patent that has this is where it's different. The owner of a patent that has the later effective filing date, the junior party, to use my language, can sue the owner of a patent that has an earlier effective filing date in a United States District Court for a judgment of derivation. This is the new law counterpart of a patent-patent interference. It's a patent-patent derivation proceeding. But it can only be brought by one party. It's no longer either party can kick it off. The owner of the patent that has the earlier effective filing date can't initiate the proceeding. That's nuts, but I think the statute is as clear as it can be on that. That's what it says. There's a very short time limit for patent-patent derivation proceedings. They must be filed before the end of the one-year period beginning on the date of the issuance of the first patent containing a claim to the allegedly derived invention and naming an individual alleged to have derived, as a joint inventor. That's a very short time period because most companies, in my experience, don't really monitor the other guys, their competitors' patents as closely as they should. So I suspect there are going to be a lot of parties that might have brought such a proceeding that they're not even going to know it's an issue until after the year is run. Patent derivation proceedings can involve any other issues. It's because it's just a district court litigation. You've got count 1, well, you can have count 2, count 3, count 4. They can have trademark issues. They can have antitrust. They can have patent infringement issues. Now, I don't think there are going to be many of those because there aren't many patent interferences. But this you're going to have. Derivation proceedings involving at least one application, again, a reissue application, in the PTO before the APJs and the newly created PTAB. Again, a derivation. The statute is not beautifully written. You've heard that before. And if you just read this section of the statute, it seems like it can only be initiated involving an application. But then there are other sections of the statute that refer to patents, and I hope that when Mike gets finished writing his rules, he's going to say that you can have a patent derivation proceeding before PTAB also involving a patent that was filed, that matured from an application that was filed earlier. Sections J and K suggest that. Again, there's a very short time limit. You've got that 1 year to get that petition on file. That's going to be a problem. There are going to be people that miss that 1 year period. There is the 1 year period we have now in 135B, but that's typically pretty easy to get around. I don't think this is going to be easy to get around. I hope, again, this is going to depend on the rules, that the PTAB in the derivation proceedings will decide what the effective filing dates are. That they won't simply look at what it is claimed. Somebody is going to have to decide what the effective filing date is, and the logical place to do it, I submit, is in the derivation proceeding itself. You can't have other issues like patentability over the prior art in a derivation proceeding, but you can have issues like patentability over the prior art in some of the other inter partes proceedings that the AIA creates. And presumably the board will allow you to start 2 or 3 or 4 or 5 of these proceedings and then merge them before a single panel of the APJs. And you've seen, I was on the AIPLA committee that wrote the comments that we submitted to you, and we argue that you ought to be able to combine these, run them in parallel as if they were one proceeding, minimize the complexity of the whole thing that way. I hope that's what you guys ultimately decide to do. If you win a patent interference, what happens is the other guy's claims get canceled. If you win in a derivation proceeding before the PTAB, that constitutes the final refusal by the office on those claims. So it's very comparable to what happens now in derivation proceedings and derivation interferences. It's effectively, the other guy is dead if he doesn't seek court review. But this is this is a hot damn kind of correction to the statute. The PTAB now has the authority to correct inventorship. What they do now in the interference proceedings is they kind of push the parties to, do you really want to have these claims canceled? Do you really want to have these claims? Or couldn't you guys get together and agree upon correcting inventorship? Now the PTAB is just going to be able to do it, correct the inventorship in their decisions. I think that's a fantastic change in the law. Regulations are going to be crucial. You've heard that again and again, and man, this is so true. The director in the guise of the gentleman sitting over here, is going to be writing these regulations. They're coming out in draft form in January. Clearly they have the authority to change from those drafts. They're not, just because it says something on January 16th doesn't mean that's what they're going to run with, but you are definitely going to be arguing into the wind if you want any significant changes at that late date. The time to have gotten the changes was this fall when they were seeking comments. And all of the major organizations, the ABA, the AIPLA, the IPO, et cetera, submitted lengthy comments, and they're totally different. Which brings me to the last slide in this section. This is where there is a bare-knuckles fight, which I will simplify as basically being between the attorneys who make their living in district courts doing infringement actions and the attorneys who do interferences, of which I'm one, but not the only one. We who do interferences got our take on this embedded in the AIPLA's comments. You know who wrote those comments. And the comments that came in from the so-called Gang of Six reflect, we had one interference guy on the Gang of Six, but that was a 5-to-1 split. And the other 5 were all district court litigators. And they want wide open discovery, just like in district courts. But when you've got that 1 year to decide the derivation proceedings, those of us who have experience in interferences don't see how that can possibly happen. We want managed discovery the way we have it in interferences. Now, I've written articles bitterly criticizing the limitations on discovery in interferences. I would like the wide open discovery. For one thing, the billings would triple if we had wide open discovery. I mean, as Keith said, parties tend to argue for things that are good for them. So I would love to have wide open discovery, but you can't do it in a year. If we're going to have wide open discovery, we cannot have a 1 year limitation on these proceedings. If you take it, the 1 year limitation, and that's what the statute says, then I think the only way they can handle it is with managed discovery, where you go to the judges and say, here's what I want, here's why I want it, here's what I hope to get, and it's a mother may I proceeding, and discovery is very limited and very managed in interferences. You can get it, and it can be outcome determined. Particularly in derivation cases, that is the most that's the time that discovery is most useful, I think. Fraud cases can be useful. But this is the hottest issue. Okay, I'm ready to go to my second topic unless there are questions on derivation. Or unless Michael tells us what the rules are going to be. No. Keith. Would you stand up and bellow?
For those of you that haven't noticed, there's a challenge going on right now between those that can litigate cases that may not have a P number and those of us that deal before the patent office. And I've seen recently in the last several weeks articles already hinting, why is it that some people that just pass the test can be able to go before the office in patent cases? Because those that litigate that aren't admitted to the patent bar now see all these new procedures for patents. And so you should pay attention to this if it concerns you, because there's a jockeying going on right now to raise the question, why is it only those with a P number that get to deal with these new procedures?
Well, it's not, because they have rules right now where attorneys who are not admitted to the patent office can get authorization to handle interferences on an ad hoc basis. And again, I have one of my articles in the IP today on the very few cases where the board has let district court litigators come in. And actually, I have personal experience with one of those people. And she did fine. She knew, she'd never done an interference before, but she was a good litigator. She paid attention. And you don't have to have a 5-digit number to handle these things. The article that you're talking about, they're trying to not so much as keep district court litigators from handling inter partes proceedings in the patent office, as it is to create a higher bar so people who have done only ex parte prosecution, they've got a 5-digit number, they've only done ex parte prosecution, and they look at one of these inter partes cases and say, my God, that's $2 million worth of billings, I want it. And they come sashaying in. And I think probably they are more likely to gum up the works than an experienced district court litigator who's never handled an interference. Either one can gum up the works. But I would guess that it's somebody who's never done an inter partes matter before who is more likely to gum up the works. Yes, sir.
You made the comment that you have
Stand up and bellow.
Well, you have the 1 year to initiate
Yeah.
the interference action. Is there any limitation under the AIA for how long it will take to determine?
Oh, yeah. The statute says, I'm paraphrasing, a year except in complicated cases where you get 18 months. It's something like that. And that's what is underlying this controversy over discovery. Because if you have wide open discovery, I don't see how in the hell you can get it done within a year.
Chief, but just one clarification. I think for derivation, they don't have that one clarification for that shows up in IPR, PGR.
I stand corrected. I thought it was.
Derivation, but we, the office, realize we need to be completed. And I think the derivation, we do complete our interferences. The average time for interference is now less than 11 months. Courts and settlements. And a few do go rather longer, but I think it's 97% are decided within 2 years. Maybe so.
I agree, but that average that your chief insists upon publishing is deceptive. It's useless information. They average all interferences. Most interferences settle. So the average pendency of all interferences, that's not what your client wants to know. What your client wants to know is the average pendency of interferences that don't settle and go to judgment. And I submit that the average pendency of those is 1 year, 11 months, 3 weeks, and 5 days. You get it done within that 2 years. And go home and decide my case. Okay. No. It's you're not the one who's in charge. Okay, how do I get it on to the next set of slides? Yeah, that's right. Prior user rights. This is another thing that we all owe to Gary Griswold. He is the father of prior user rights. And the section of the statute is a Gary Griswold special. How we handle them now? Well, the current law provides that use by others in this country, in the United States, underline that, before the invention by the applicant of the subject matter claimed in his patent application, before the invention thereof by the applicant for patent, is a bar to patentability. Okay, so that's the first thing. If it qualifies as use by another, it can be a bar to patentability. The word use has been construed as meaning public use or use in public. How public it has to be, extremely complex question that's led to what I believe to be howlingly funny opinions. One involves a Girl Scout troop that went on a tour through a DuPont plant where they were practicing the invention in big pots. And the Girl Scouts walked through and they saw these pots and saw fumes coming off. That was held to be a public use because the Girl Scouts saw the pots. But anyway, that's not what I'm here to talk about. But we've all dealt with public use and how public it has to be. Who has to see it? Does the person who saw it have any capability of trying to figure out what the hell is going on inside the pots? Apparently not. But this is where we get to the Gary Griswold business. In addition to being a bar to patentability, it may lead to a personal right in the entity that used the invention previously. Prior users in the United States, current law, 273, its only methods of doing or conducting business. Well, DuPont, those big urns where they're mixing chemicals and heating and stirring and all that, are they conducting business? Well, they sell the chemicals that come out of the end. It sounds like a business to me. But what it really means, these are the computer program cases. These are the bank, that kind of business. So it's very limited, and there have been very, very few cases making use of it. Current law provides that if a business method is actually reduced to practice by another entity at least a year before the effective filing date of the patent and used commercially, the statute has used commercially, commercial use, various variations on this repeatedly, before the effective date of the patent, whether or not the subject matter at issue is accessible to or otherwise known to the public, that inventive entity, or practically speaking, the company that employs that inventive entity, has a personal right to continue using the patented invention commercially. It's a complicated provision, but it's nowhere nearly as complicated as the corresponding provision in the AIA that we'll get to in a moment. Prior user right is a personal right. Patent is still valid and enforceable against companies that are not entitled to the prior user right. There is an exception to the requirement that a prior user right be based on commercial use. Words mean what Congress says they mean, and they do not necessarily mean what any normal person would think they meant. So this exception says that activities performed by a nonprofit research laboratory, a nonprofit entity such as a university research center, what does that mean? Or hospital. But if and only if the public is the intended beneficiary of the use, well, any university research center or hospital that I have ever had anything to do with think that everything they do is intended to, the public is the intended beneficiary of everything they do. So at least the way they interpret it, that's totally circular. Are statutorily deemed to be commercial uses. Well, they're not really commercial uses in the normal sense of the statute. What they are is something else that gets the benefit of the prior user rights. But instead of saying, if you're a hospital, you get the prior user right, regardless of whether it's commercial or not, it says that that's deemed to be a commercial use of a university. So again, it means what Congress says it means. However, the nonprofit research laboratory, whatever, has to keep using it within the hospital, laboratory, whatever. So they don't get to go to Johnson & Johnson or one of the other big, clearly commercial companies and pass on that right. Now, how it will be handled under the AIA? Basically the same, only 3 times as many words and significantly more complicated law. The big difference, though, is that the scope of the activities that can give rise to this personal right has been enormously broadened. We're no longer talking just about banks and that kind of stuff. The computer program cases. Subject matter consisting of a process or consisting of a machine, manufacture, composition of matter, that's 101, used in the manufacturing or other commercial process. It's not limited to a method of conducting business. I think that's everything. I mean, nothing occurs to me that you can patent that isn't covered by that. So I think prior user rights now have the same scope, the ability to have a prior user right has the same scope as the ability to get a patent. If that's not true, I don't see the distinction. Prior user right is still limited to a commercial process. The defense is limited to a person, this is maybe implicit in the current statute, but it doesn't say it. A person acting in good faith. You know what that means? My opponents are always acting in bad faith, and I'm always acting in good faith. Apart from that, I don't know what it means. A person who acting in good faith, commercially used, again we have that limit, the subject matter in the United States, either in connection with an internal commercial use or an actual arm's length sale or other arm's length, there should be use, I think, in there, of a commercial transfer of a useful end result of such commercial use. The other limitations in the prior user right are similar but not identical to those under the current law. Again, you have to have been doing it at least a year before the effective filing date of the claimed invention, or the date on which the claimed invention was disclosed to the public in the manner of 102B. 102B, this is what Keith and Bill both were talking about, that limit, that's the disclosure business. If you go out and disclose it in the manner recited in the new 102B, that also is the key date for determining whether you have prior user rights. Section for nonprofits has been brought forward in its entirety, but a new exception. So you've got rules, exceptions, and exceptions to the exceptions. This is what keeps lawyers off the streets and keeps us from panhandling with little clean cups. Very complicated. The defense is not available to a university or tech transfer organization unless we talk about ambiguities. And there are a whole lot of things in the AIA that I can, as a lawyer, I can say I can argue it means this, or I can argue it means that. And either one of these interpretations is plausible. My nose will not grow if I argue either way. This one, I just have no earthly idea what it means. It's not ambiguous, it's gobbledygook. Unless the activities required to reduce to practice the subject matter of the claimed invention could not have been undertaken using funds provided by the federal government. Now, if it said was not undertaken using funds provided by the federal government, I'd know what that meant. But could not have been undertaken seems to imply whether or not it was undertaken using funds provided by the federal government isn't the issue. That's not the point. The issue is, could it have been? Well, federal government prints the money. They give. Why couldn't any reduction to practice could have been done with government money, right? And it could have been done with private money, and it could have been done with Japanese money, and it could have been. So what the hell does that mean? Yes, sir.
Without stem cell research, or the federal government is saying no, we're not going to fund that.
Well, that's what the statute says currently, but if they give you the money, you can do it. It doesn't say. All right, he's got an argument, but I don't think that that's what it says. Because if the government gave you the money, then you could have done it. What? I can't stand up and bellow, please.
Could you repeat what you said?
Oh, he says stem cell research cannot be done under using funds provided by the federal government because there's another statute that says the federal government will not give money for stem cell research. But that statute in itself could be changed tomorrow. I don't know what that means. It's fascinating. I don't think I'm ever going to be the one to litigate that issue. Subject matter for which commercial marketing is subject to pre-marketing regulatory review is deemed to be commercial use. This is something that gives rise to this personal right that you can't keep track of, practically speaking, because most of these things are either really secret or substantially secret or at least non-public, unless if you're Johnson & Johnson and you have your agents out there in the hospitals monitoring the programs that your competitors are doing, you may have a general idea of what they're doing, but it's really hard to know about this kind of personal defense. Although the defense is personal, it can be transferred, but only by selling the whole damn line of business. I think that's implicit in the current statute, but it doesn't say it in the current statute. And if you do transfer it, you can only continue, the personal right only applies in the same factories. So if you're a little startup company and you've got one factory in Palo Alto, California, and you're making a ton a month of the stuff, and you sell that whole business to Johnson & Johnson, they can keep making it at that factory in Palo Alto, but they can't start making it in every single factory that they own around the country. The personal defense extends only to the specific subject matter that you were making prior to the key date, except that you can make improvements as long as the improvements do not infringe additional specifically claimed subject matter. People kept coming up with hypotheticals. Is it really fair to have the personal right apply to here, to here, to here? So the statute as a bill kept getting longer and longer and longer to cover every hypothetical people could come up with. Also, if your little factory in Palo Alto goes out of business or starts making something else, so you stop making that subject matter, the personal use evaporates. You can't go back and start it up again. So you've got an abandonment issue here, which probably, I think, means the same thing as abandonment in 102C. Maybe. And maybe it doesn't. I don't know. Somebody's going to litigate that. That'll be worth a couple $100,000 in billings easily, probably a couple million in billings. All right. This gets to this is Mr. Boundy, your friend who thinks that the sky is falling, and Mr. Boundy is one who sees the worst in all of this. I do not see the worst at all.
Hey,
Keith.
one quick question, Chico. What about upgrading of production?
Oh, I think that's covered.
Is it covered? That was
Yeah, let's go back. Defense also extends to variations in the quantity or volume of use of the claimed subject matter. So if you're making a ton a month, I think clearly you can upgrade that line and make 2 tons a month as long as it's still in the factory in Palo Alto. And you can improve it so long as you don't infringe a different claim. They try to cover everything. All right. The argument that Boundy made the last time we did this is that this is horrible. Western civilization is in peril because you're going to have to keep records in order to rely on the prior use exception. Well, that depends, I think, on what it is you're trying to prove. The key factor in all of this, I think, is the commercial nature of the use. The statute really drills home on that. It has to be commercial use. Well, any company, whether it's Johnson & Johnson, Eli Lilly, DuPont, anybody that is really making commercial use, they have to keep business records. You cannot run a company without keeping business records. And the business records are going to be voluminous and easy to access and to prove. So if you are just trying to prove, we've been using this commercially since October 1998, that ought to be easy to prove. The only time that it gets dicey is if you're trying to prove the actual reduction to practice aspect. And yeah, that can be difficult. That's something we do all the time in priority interference. And if you have a client that doesn't keep good records, and God knows I've had some of those, that can be hard. If you have most normal American clients, I have this problem with foreign clients more often. But most American clients, they've got records that you can use. You do not have to have the kind of laboratory notebooks that you were taught in second semester chemistry you should prove. God bless you if you do keep those good laboratory notebooks. That certainly makes my job easy. But you can prove actual reduction to practice using any kind of normal business records that companies keep, including when samples were sent from laboratory A to laboratory B for some kind of an IR exam or something like that. You can use these things to prove. It's not, I think Dave immensely overstates the difficulty of proving actual reductions to practice on average. Now, bad things happen. I had a case where the client insisted they had kept meticulous record and they had them all in a separate building out behind the factory, and there was a hurricane and the building was destroyed and all their records were destroyed. Well, things happen. And sometimes I believe the client, they'd done what they said they did, but I couldn't prove it. And as my evidence professor said, if you can't prove it, it didn't happen. Okay, that's it. Questions on this? These proceedings are, under the old law, are very rare. Under the new law, since they have tremendously broadened the scope of the prior user right, it seems logical to assume we're going to have at least more litigation and possibly a lot more litigation on this.
Thank you, Chico. Any questions? So we're going to break for lunch. Lunch is going to be in the same room where we had breakfast this morning, room 115. So head towards registration desk. Restrooms on the left, lunch on the right. Pick up your lunch and come right back here. We're going to try to start around noon, but 10 minutes might not be enough for everybody to grab lunch. So the sooner we can get back, the sooner we can get started. So you know where everything is, and please head back by about noon. Thank you.
Anybody want to talk about my topic? I'll hold down here for a while.
Joel R., thank you very much. It looked to me, Eric, we probably used to have a team. That's it sounded as though you've already made some headlines for have somebody who's accelerated won't have to go accelerated in a later process. Come through regular slow speed. Those issues already have the demo tests. That's absolutely right. I was afraid you were saying, I was hoping you would say, no, that's wrong, because the solution to that.
Not yet. That's one of the sections. I believe there is legislation. But often we don't know whether they're going to be substantive changes.
It looks like the combination of you better ship one without and you could slow path through like continuation practice. A bad actor could come out with a patent that they derive that has an earlier expected filing date, but isn't challenging.
If the parties become aware of each other and
Non-public.
and send information